We're live.
Good morning, this is Senate Natural Resources and Energy, and it's the 26th of March, and we're gonna talk about 723 today, and we're gonna start with Representative Larry Sakowitz, who is the sponsor of the bill.
Thank you all for having me. The record Larry Sakowitz, representing from Randolph. Here to talk about 723, bill concerning posting of land. This bill was initiated because of some guidance that was given by the Fish and Wildlife Department last fall that seemed to indicate that what the current practice was around the dating of signs that are for posted land. Instead of the dating being from the moment you recorded in the town hall with the town clerk. From that moment, 365 days. The guidance that the commissioner gave was that it was from January 1. It was a reinterpretation of the statute, saying that it was good for the calendar year instead. This was not the common practice and caused quite a bit of consternation amongst lots of landowners. And there was a bunch of requests for us to make the law clear. And so this bill came out of that. And so one of the things this bill does do is it makes it very clear that the posting is valid from the date that the recording is made with the town clerk for 365 days. But we also made two other changes to statute. One change is that the dating of the physical signs is no longer required. We heard a testimony that this physical dating of the signs every year is a burden to landowners. We didn't hear, at least in my mind, compelling reasons why landowners were required to make this change every year. And so we dropped that requirement. We also learned that Vermont is an outlier in terms of how this is done nationwide, being the only state that requires the annual date of signs. And so this puts us more in what other states are doing all around the country. And then the other change we made was response to testimony that we heard concerning the detailed rules around the placement of signs. And so we heard in testimony stories like there's a landowner will call a warden because they felt like the posting was being violated. And the warden would walk the property to see if it was properly posted. And if there was the slightest defect in the posting, the entire property would be considered not posted. So, a hunter might have entered the property on one end of the property, which looked properly posted. The warden would go around the property, and if they saw a single sign anywhere, it could have been nowhere near where the sign, where the hunter entered the property. If there was anything wrong, the entire property would be considered not posted, and that seemed unreasonable to the committee. So we heard, for example, that if a single sign had been taken down, right now the signs are required, and this is still the case. Signs are required to be no more than 400 feet apart. If a warden would go out with their tape measure and find that the sign was 401 feet apart, the land would not be considered posted. And so the other thing that the committee did was we inserted a reasonableness requirement into the law, which says that, in my words, that if a reasonable person were to look at the property and see and it seems to indicate that it's posted according to the guidelines that are in statute, then we consider it posted. Landowners required, if they find out that they're not meeting the technical specifications, to make the fix. But for that particular moment in time, it would be considered posted. And that's the bill. That's what we did. It's pretty short and sweet, and we're very happy that we've gotten a majority of the committee and House to agree. And we have questions about the answer.
Go ahead.
So in this construct, let's say a hunter stops by the town clerk's office, determine where the posted areas are in that town, and then they you know, proceed to a parcel of land which they believe not to be posted. But they see signs with no date on. What should that hunter do in that situation?
You should ask the landowner. That's what they should do. And we heard in testimony, and pretty clearly that the vast majority of hunters hunt on land when they have permission.
Right. So
And that's the common practice. And one of the things that we heard in testimony as well is that the problem that we're trying to solve by making these additional changes to the law are problems that are caused by a very small number of hunters who are belligerently not following the spirit of the law.
Okay.
And so what we heard is that these changes that we made will have virtually no effect on the vast majority of hunters, people who are belligerent to do it like that.
Okay, so that's what they should do. Legally, let's say that hunter enters that piece of property that is not registered with the town, but there are signs around with no dates. Legally, is that hunter or landowner in violation of any statute according to what's here?
My understanding is that that land is not legally posted if it's not recorded with the town program and uses.
Okay. Okay, all right, thank you. Okay.
Thank you. Thank you. This is helpful. I'm wondering about this. Is there in current law, I don't think it's in the bill, but is there in current law something, if somebody defaces posting signs or takes them down, is there a penalty or violation for that?
Yeah, my understanding is that that is not a violation of wildlife, fish and wildlife rules or statute in that section of statute, but it's covered in other cases about animals.
Okay.
Be a better question for
I'll ask.
representing for council children.
Yeah, we'll take a piece.
Though there's a couple different bills floating around out there on posting. But there's also two different issues because they're two different titles. What you're talking about, when a game warden shows up, that's Title 10. That's very specific in there how you have to be legally posted. Certain conditions have to be met. Then there's I'm not sure which title it is. There's another one that if you just put up 5 or 6 posters on the roadside, you go down and register with the town clerk. You're still legally posted, but the problem is that there's no poster on the backside of the property. So when somebody goes out, happens on your property, not really knowing where that property line is, because very few properties in my district are actually surveyed and flagged. Somebody sees them on their property and they call a warden. The warden shows up and says, I know, because I used to be a gamer. He shows up and says, well, I'm here primarily to enforce Title 10. And legally, you're not posted to enforce the Title 10.
Yeah.
But there are the other statute allows them to be prosecuted, but not criminal, you want to understand. So we're gonna hear from legislative council on that.
Yeah, and that brings up, I think what you're bringing up is more of the sort of, or when someone enters land, are they doing it under Title 10, the hunting parts of our statute, or is it just trespass that's not supposed to be on the property and you do, and that makes everything a lot more complex. And it's pretty extensive testimony around understanding the differences and the nuances in these laws.
I mean, I'm also a hunter. If I show up and I see it, realize because according to Fish and Game law, they have to be no more than 400 feet apart. You have to walk between and the trees block view of the other poster. I don't know. Once I realize that, an ethical hunter would say, hey, I'm on posted property, I really should leave, or go get permission.
Yeah.
Because there is a provision in there for posting with permission only. For hunting with permission.
Yes.
I need to step up for 15 seconds.
Oh.
And we'll go to course. I'll be back in 15 seconds.
Okay, fine.
Okay, we're back with short break and with Representative Larry Sakowicz from Randolph.
That's correct.
And just reported the bill or any more discussion?
What was the vote in the committee?
The vote was 9-2.
Okay,
Okay.
yeah, I mean, it's a pretty straightforward bill.
Thank you for taking the.
You want
We have multiple on our
Welcome.
wall, so we, bills about this on our walls.
Yeah.
We heard you all were doing it, we're like, okay, good.
Yeah, I was very happy with the discussion that we had in committee, very happy with the resolution that we got to, and it's a good one. Thank you so much for having
Thank
me.
you. If you want to stay for the further discussion, you're welcome.
Well, I should probably need some back to my committee, so if you have further questions for me, please do let me know.
Okay, next we're gonna have a bill walkthrough with Brady Shulman, Legislative Council.
Morning,
Good morning.
Brad Showman, also Legislative Council, I'll be walking through the version of the bill that's as passed by the House. And I'm looking at the unvoted that we have the same copy. So this bill, makes some changes to how to police your land against hunting, fishing, trapping, taking game or wild animals, and we will start with the bill here. So it's in Title 10, Section 5201. We're on page 1, lines 6 is where we're getting started. Some conforming changes to change our language to conform to standards, drafting standards. And then we also changed some language in starting at line 10 to make it consistent in this statute to say that we're referring to hunting, trapping, or taking a game or wild animals. Just changing that language to be consistent throughout. So no substantive changes at this point. Also changing section B to make sure that we're just referring to notice signs to make that clear. We're not changing the requirements of the notice sign with the exception, as Representative Sakowicz said, with the exception of changing the date requirement and removing that date requirements from the notice sign itself. So those signs no longer have to be dated, they still have to be maintained, and notice signs still have to be of the standard size and design as the commissioner shall specify. Subsection C states that the notice sign shall be recorded annually with the clerk, and it defines that annually, it states that the posting shall be valid and enforceable for 365 days after the date the posting is recorded, just to remove any ambiguity about whether the posting is good for 365 days or just the remainder of a calendar year in which it is posted. No further changes there. So section D, we are making 2 changes. One is we're clarifying the practice, but there was a question mark about this in a footnote on the Supreme Court case, clarifying the practice that the land has to be posted and recorded as provided in this section in order to be enclosed for purposes herein. There was some question whether the land has to be recorded in order to be enclosed, and this section clarifies what the committee thought was the practice, is that the land should be recorded in order to be enclosed.
Which page?
We are on, my apologies, we are on page 2, lines 15 and 16.
Okay.
Moving on, and this is a change here to address an issue that Representative Sakowicz discussed. Accidental or unintentional deviations from the requirements of subdivisions A and B of this section shall still be deemed effective to prohibit or permit by permission only hunting, fishing, trapping, or taking game or wild animals if the notice signs would lead a reasoned person to believe that hunting, fishing, trapping, or taking game and wild animals is prohibited on the land. Property owners with actual notice that their signs deviate from the requirements of the section shall take reasonable steps to ensure that their notice signs comply with the section. This bill shall take effect on passage. Just to give a little bit more context on D. So the land, you'll notice that accidental or unintentional deviations from the requirements of subdivision A and B of this section. The reporting requirement is in subsection C, so this does not give a property owner, this leeway, so to speak, on the reporting requirement. It is just on the actual sign itself and the requirements that are in statute and incorporated by statute, in subsections A. And that is the bill.
Go ahead.
Couple questions, at the bottom of page 2, property owners with actual notice. What is actual notice?
When they subjectively know, so when they have knowledge themselves that they know that their signs are out of compliance, they have to take reasonable steps to
What, does that mean somebody's told them, or they just have a feeling that their signs are out of?
That is, so actual notice, that is a good question, because actual notice is what we call a subjective standard. So that means what a person actually knows themselves. And so it is, if a person has a feeling that their signs are out of compliance, a reasonable person would take steps to ensure that their signs are in compliance. So, you know, perhaps an example might be we had a very strong windstorm that knocked down a bunch of fencing that the property owner knows that their notice signs were posted on, right? So that property owner might not have actually seen the notice sign on the ground, but they can have a feeling, they can be reasonably apprised that their notice signs are have been taken down and should be taking steps to fix those. And then, but it is a reasonable steps, right? And so if their property is dangerous or you know, they're not able to access their property based on a natural disaster or something of the sort, they wouldn't necessarily be required to do that immediately. We're talking what a reasonable person would do. So what a reasonable person would do does lack specificity in the statute. However, it also tries to encapsulate the realms of possibility. We're dealing with land, nature, and having the reality of having these signs outside. And someone just might not know that one of their signs blew down, and they're not aware until they call a game. And they say, oh shoot, one of my signs is down. I had no idea. Allow me to fix that.
Okay. Or it could be somebody saying, hey, noticed your signs are out of compliance.
Yeah, so someone tells them.
Okay,
Then,
but it's not just like they were not aware and then they're suddenly not in compliance.
that is correct, right? So if you're not aware. And then you become, you know, you call the game warden or something, and then you become aware. That does not mean that your land is no longer enclosed, just because you have one of those kind of accidental or unintentional deviations from the strict requirements of the statute.
Okay, and then my question before about I guess it's vandalism, if somebody takes down, are there penalties specific to land posting signs?
Yes, there is,
Okay.
and it's in the, in this section of the statute. I don't have the number off the top of my head, but it's a between $25 and $100 civil penalty.
Okay, for somebody taking them down or
Yes.
vandalizing.
Yeah.
Okay.
So if you could recap just what this bill does, is different than what the statute states, right?
Yes, so this bill removes the date requirement. And it permits and it clarifies that posting is the recording of the posting is valid for 365 days after it is recorded. And then it also permits accidental unintentional deviations from the posting requirements, so long as the property owner did not have actual notice that the signs were out of compliance.
So I've had, I think we had the Commissioner of Fish and Wildlife. And he presented his, Fish and Wildlife side of the posting issues. Part of it was, I'm gonna not paraphrase it, but I'm gonna try and use my memory.
What's next on our,
Yep,
the commissioner,
okay,
yeah,
yep, so he said that basically, by requiring the dating. At the time, the issue was the date started in January. People didn't want to have to go out in January and redate their signs. By requiring the dating annually, I think that his recommendation was that we push it back to whenever you originally posted. That people are gonna go out and make sure that their posters are still up.
Mhm.
You get a windstorm or some, tree falls over and knocks it down, then when you go to redate your signs, to make sure it's legally posted, that you would notice then that your poster was missing, so. So, anyway, that's my 2 cents on it, and still being open-minded about it, and we're gonna hear from the commission. Anything else?
Thank you very much.
Representative Starkowitz just emailed me and said the vote actually was 10-0-1.
10-0 what?
Yes. Also, we're waiting for 10:40 for the commissioner to show up, so we'll take a little break. 9:40, 9:40, sorry. We're live again.
Hey, good morning. This is Senate Natural Resources and Energy coming back from a break. And we're joined by Commissioner Fish and Wildlife, Mr. Batchelder. Welcome.
Thank you so much. For the record, Jason Batchelder, Commissioner Fish and Wildlife. First, thanks so much for having us to hear our comments on some of the nuances of this bill. I'm joined by General Counsel Ken Smith and Colonel Stedman, who's the Director of the Warden Service. And I'll read through my comments. We didn't rehearse, but I know that Hannah has some thoughts on enforceability around strict liability and intent around the reasonable person standard. Forgive me if I say your, I know this bill in its form is something that you're only receiving. And the Colonel may have some thoughts as well. And we're always happy to come back and elaborate more on any of the questions you might have that you feel are going to take longer. But I want to say special thanks to the House Committee. I did listen to Representative Sakowicz roll this out this morning. I know they put a lot of work into it, and they're proud of the bill, and they should be. But I'll get into it here in case we run long. There are three pieces to this. The first being a landowner's ability to post 365 days a year. I think that was our very supportable from our perspective, and something that we feel did away with the consternation around posting it difficult times of the year, which fully take responsibility for again. But I think that makes everyone feel good, and it clarifies a nuance of the statute that we felt some people were okay with and some people weren't. Landowners, wardens, prosecutors, that's attorneys, the living. But second, the bill in its current form removes a dating requirement, and I'm not going to oppose or support at this moment, but I do want to expose what we feel could be a vulnerability. So on its basis, this would appear to remove some burden on the landowner who, as the law stands now, has to visit signs once a year to add the date. Dating signs, we don't feel it is a frivolous or burdensome ask that the department places on people, or the statute places on people, but it's a step that places a person on the landscape and on their land boundaries to ensure that signs are present. Language has been added that we'll try to cover this issue at the end, which I'll talk about also, but as we've spoken about it, posting is a right to hunt in Vermont. And so posting should be a deliberate act. So putting a landowner on the landscape to ensure those signs are there is what we feel dating does. If we don't have dating, I being a human myself, signs are there, what could go wrong, right? Years go by, signs go down, squirrels make nests out of signs, and they're no longer there. And while I feel that a hunter and an angler must exercise all prudence to ensure a landowner is respected, I do feel that a landowner must acknowledge that there are hunters out there, anglers out there on the landscape who are due some acknowledgement of their right to hunt. Legible dated signs are good fences, which, as we know, make good neighbors. And I'm not talking about people who willfully trespass here. I'm talking about unknowingly crossing someone's boundary in a snowstorm, having signs not present. Whereas if there were dates there, I feel like we could cover that. And that's just a word of maybe a little experience, a little bit of caution. And I said I would be quick. I'll wrap up by saying I would like to again caution the committee around what might be seen as the fail-safe language at the end, which I believe will contribute to a difficulty in prosecution, which is the reasonable person standard. Proving a person is reasonable removes strict liability for wardens. And strict liability is an aspect which Fish and Wildlife law generally relies upon in Vermont. Sort of, you didn't have to know you were speeding, you just had to know you were driving, right? We put some laws in place. You just had to know you were hunting, and you cross this line and you're guilty, right? We don't like to put the burden of intent or the burden of reasonableness on a standard. Not to say that we couldn't live with this in its form, right? We understand that we're not in the driver's seat here, and I'm respectful of your wishes. But again, proving a person was reasonable is similar to proving a person intended to do something. And I would love to offer the colonel or council to elaborate if you wish. Wardens do like cut and dry language, and when they have it, prosecutions can happen. I think there are other folks in the room who can attest to that. And I think having this language, this sort of, folks have called it de minimis language, and I don't exactly know what that means, but sign blows down, still prosecutable. I think that that's asking for a limited interpretation as we get on the line in the course. But that's generally all I have, and I'd love to take any questions that you have. I did hear a question from the committee on, is there a fish and wildlife law that prevents signs being tampered with in areas? It's 10 VSA 5205, and I think it's a 10-point criminal violation. You could back me up on that. But certainly it is against the law to mess with any of the signs, and it can lead to a loss of license and criminal investigation. If any of that was mealy mouthed or not clear, I'm happy to elaborate, but basically wanted to offer my 2 cents and any help we can provide.
I don't think I have any questions at the moment. I am just appreciating your comments on the switch from strict liability to reasonable person type standard. Now, at this point, it sounds like you're willing to go with this, that this is fine. It's the preference. I just want to make sure that I'm understanding.
Sure.
The preference of wardens to have more, so I guess black and white, or just clear language, which you feel like a strict liability standard would be more black and white.
Strict liability is always better with fish and wildlife law because it's most of the time it's unobserved, and you're dealing with people who are relying on their own ethics, right? And so can't have wardens everywhere when a person is caught trespassing. We don't like to have to interpret what the intent was, and having some sort of reasonable person standard is a challenge for us, because not only do you have to prove that the event happened, but you have to prove that this person was reasonable, and then lump on, say, the right to hunt for a person. I think I just feel like it's asking for trouble. Full disclosure, I've had some trouble wrapping my head around this scenario, what it would look like to prosecute a person who unknowingly trespassed or maybe willfully trespassed, saw that a sign was down and then took a liberty to cross, right? Not that would happen, but let's say that did, or a person blindly stumbled through some posted signs in a snowstorm, let's say following a deer track. They didn't see the signs, they would still be prosecutable as they would be as the law stands today. If they walked squarely between 2 signs that were 400 feet apart, they would be guilty today, right? But now proving that person was reasonable adds gum to the works.
Yes.
Well, if the snow is so blinding that they can't see the signs, should they be out there shooting at something that might be
Fair point.
not a safe thing to do, but I think this, and Bradley's not here to ask our attorney, but I think this is a reasonableness standard for the people who are posting the signs, not for the hunters. And so it's that the property owners have to be, make reasonable efforts to post their land and to keep their signs in good order. Actually, it doesn't seem like it's the opposite. On the other side, there's not a reasonableness standard.
So I've got it up in front of me here, and it says, if notice signs would lead a reasonable person to believe that hunting, fishing, trapping, or taking game of wild animals is prohibited. That is pointed at the hunter or the
Where?
the would-be
Which
trespasser.
line are you on? I'm sorry.
That's okay. It's line. The reasonableness person, a reasonable person is line 20 of page 2.
Okay.
Of your new draft.
Oh, I see. Okay, so it is on both sides. Okay,
Yeah.
fair.
And there are reasonable steps that a landowner would have to take, which we understand. And again, I don't want to lean toward the negative here, but I don't want to say that this won't be this won't be a challenge, but I do think it will be a challenge, taking, a piece of the strict liability away. And I also understand Colonel didn't get dressed up for nothing, so if you'd like to hear from him, more law enforcement center form, please.
I'm good.
So I know wardens have broad police powers, not only fish and wildlife, but also civil knowledge. So I'm gonna ask you to put two different hats on. If somebody is not legally posted according to fishing game law, they at least have the intent to post. And somebody calls fish and wildlife or the dispatcher and says, hey, I've got hunters on my land. That kind of triggers, oh, I should contact the warden. And you get there and find out that the land is not posted legally in accordance with Fish and Wildlife Title 10. But the landlord wants to have the individual prosecuted. And now the warden is a law enforcement officer. Which hat is the warden wearing?
I'd like to defer that to the crowd.
Would you like to come address?
Because there's two different
No.
titles that affect posting.
Sure.
Title 10 and Title 23.
Hi, good morning, for the record, Justin Sedman, Director of the Warden Service. So you are correct, Senator, Title 13, for what you're referring to, criminal trespass.
I knew that's three.
Right. However, Title 13 also has a reasonableness standard in it. And I can give you a very personal experience about this. So this fall, an individual trespassed on my in-laws property, which is public. He was trying to impress a lady friend and was out going around in the hayfield. They interacted with the individual, called local law enforcement. The individual drove by no less than 5 persons, however, his name was not seen. The individual was given a notice against trespass, because as a general rule, the reasonableness standard is used as a defense that is well received by the courts. And so typically in first offense criminal trespass cases, a person is given a notice against trespass. They are not charged. Even though my mother-in-law was, she was what I said about that, I warned her, but the advantage, and to be clear, I don't personally post my land, I do help my neighbors with theirs, like, and I don't mean this flippantly, I don't care what comes out of this, other than to say, if the landowner takes the time to post their land properly, I believe people who trespass deserve to be prosecuted, and currently we can do that. Under the current language of Title 10, poaching private reserve, which is the section we're talking about, I didn't know, I didn't see the signs, I didn't mean to, none of that matters. It is strict liability and we prosecute people and we are successful. If we introduce a reasonable person standard, I believe this will go the way of Title 13, which is then we will no longer prosecute. We will give notices against trespass, which those also expire after 2 years, so then someone comes back, they get noticed again. So it creates this OODA loop of not actually getting prosecutions. That's my fear of this. And I, again, if that's the way the body goes, then that's the way they go. We'll do the best we can with it. But there is no wiggle room in the current existing in the book, not the bill. In the current language, there is no excuse. You either did or you didn't, and that's all that matters. And we have successfully prosecuted that on more than one occasion, and people have said that, I didn't see it, I didn't know, it was a snowfall, it doesn't matter. It doesn't matter.
I mean, this might be a question for Rep. Sacklitz, in trying to understand, because that, as you pointed out, there's and I missed the first time, there's a reasonable standard on both sides, so it's the hunter or angler or whomever. Do they reasonably believe that the property is not posted, and therefore they have the right to be there? And on the other side, did the landowner make reasonable attempts to make sure all their signs are in good order, right? So it seems to me that maybe they were trying to make it sort of reasonable on both sides, and they didn't want to do one or the other without doing both, to make it you know, fair to both sides. I don't know if that's was their reasoning, I'm not sure, but.
I would just equate this to a recipe. Some things look really good on paper and then you bring them out of the oven and they don't, it's very good.
But it sounds like the way you're interpreting it. For under current law, the strict liability for land posting is also like. Excessively strict, like you're literally tape measuring out 400 feet and, you know, if a sign doesn't have the correct date because. It's been rubbed off, you know, then it's not bound to be posted, so that seems frankly unreasonable, so I think maybe they were trying to get some kind of balance with it.
Completely understand and respect that, and that's why I said, I don't want you to say my testimony, is like, I am trying to lead you in one direction. I'm just telling you, from my perspective, this language will make this law nearly unenforceable on first offense, which seems to me to undermine what that committee was trying to accomplish. And if it ends up with this, then we'll do the best we can. But I suspect, simply based on my experience with the criminal justice system in Vermont, it will lead to a lot of very angry landowners because the wardens aren't going to be able to do anything. And my personal interest in this is that the anger is then directed at the law enforcement officer, because the landowner doesn't necessarily care about the downstream side of the criminal justice system. They deal with the officer or the warden who's in front of them, not the courts and prosecutors who say, I'm not making mistakes.
So would you be in favor of taking up that first reasonableness and just leaving in the second one?
Any reasonableness standard will muddy the water and make it challenging to enforce. There is only one comment about reasonableness in Title 13. It says, if the signage would lead a reasonable person to believe, that's all it says. And it is next unenforceable offense. So, and I say that to say, if you have a reasonableness standard in here, I believe there's a good chance we'll end up there. That said, one would certainly be better than two, because two really muddies the water, but any reasonableness standard will be deferential to the person trying to take advantage of the situation, i.e. the person on the property.
Okay.
Again, please don't, literally, like I said, I don't,
I'm
that's
just
my
trying-
land, so what, I don't.
I'm just trying to understand it. It's the first
Yeah.
time I'm looking at the bill. I mean, these are the nuances that we have to understand in order to make a decision,
There
so
is-
don't worry about it.
There is no doubt that the current posting language is challenging, and it sets the bar at a level that Title 13 does not. But on the flip side of that, that's what allows us to say, doesn't matter. I don't care if you didn't mean to, you did, here's your ticket. Go to court, and judges have routinely upheld that. We have not lost cases of poaching prior to serve because someone went and said, I didn't know, I didn't see it, it's not.
Right, no, I understand that, it's just on the other side,
Yes, yeah,
that other
right.
side, like, it seems like excessively unreasonable, truly.
And right, so to get to that level of it doesn't matter what your excuse is, it's a high bar on the front end to say you have to create a situation that allows for this to happen.
And that's why I'm saying, like, if one unreasonableness is better than two, then maybe we
It
just
is.
do it on one side and not the other.
I would certainly say it.
Okay.
Yes, go ahead.
So. The only thing that's really changed in here is the date, and we took testimony from you before. And you backed away from the, January 1 date and said when, you would accept. That when you originally posted land, you went on 4th of July. And you got people there, celebrating the 4th, and they go out and help you put posters up. That starts your annual day.
Posting party.
So, and I think, this is a complicated situation because we're talking about two different constitutional rights. Constitutional right to hunt, fish, and follow, and to own and protect property in Vermont. So, from the enforcement standpoint, I'm hearing you say that it's it's a lot easier on the warden to enforce the law as long as it's in accordance with Title 10, the way it is now. On Title 13, it becomes more open as far as interpretation. One of the problems I have as being a legislator is a lot of times we make laws that we either don't intend to enforce or we can't enforce. So, do you have any other, I mean, if I have to vote on this bill the way it is right now, I'm support it, because I think by requiring people to date their signs, they're gonna go out and make sure that those signs are up. And, you know, if they blow down, well, they got a responsibility to put them back up if they're gonna be legally posted. So,
I do have comments that I think might reset this, and if I missed the mark, I apologize, but looking back at where we started here. The consternation that I brought through the reinterpretation of statute, which was the words used this morning. We were in a good place, except we had this question that would come up every year. The first piece that I mentioned this morning, the 365-day allowance, fixed that in our minds better than we could have hoped. It not only allows someone to post on a day that they choose, but in our minds, and council can weigh in, it allows someone to go out and write 2026, 2027 on that sign, which some folks allowed in the past and some folks didn't. And then all you have to do, if you don't want to go out and visit your signs again the next year, which is up to a landowner, go to the town clerk and re-register that next year, pay your $5, and you're good for 2 years. And then in 2027, you go out and you write 28, 29 on it, or whatever. I may be getting my dates wrong, but hopefully the point is across. So feeling that is achieved. The other two pieces, I feel we could live without. Adding again the reasonable standard. I think we've beaten that one enough. But getting to the point where we were a year ago, and granted, this brought a lot of awareness to posted land, a lot of landowners' voices were heard, and they still will be heard, and I'm appreciative of that. But going back to this day last year, we simply wanted clarification around when a person should post to allow people to have 365 days of posting that no attorney could argue with, or no defense attorney could argue with, no warden could argue with. And we're there with 365 days of posting. Add a day to it, it adds landowner accountability, and it allows for a hunter to see on those signs, yep, back away, or they go knock on a door, I feel maybe. But I do feel all the work that went into this, I do feel that the reasonableness standard is a challenge for prosecution and forward. So 365 days, I think, gets us there. The date is we talked about the date. Removing the date just removes the accountability piece. And I know that's hard for landowners to hear. Why should I be accountable? But I do hope that my point is the whole footprint of the farmer argument, right? Getting on the land and having an intimate connection with your boundaries by dating will ensure that happens. And I hope that's not too burdensome or too hard for folks to hear. But I don't mean it in a burdensome way. I mean it in a real way. If we don't require dating, we're going to have science lapse. Does that make sense?
it is, as much sense as my question of it, really is a statement.
Okay. And I don't want to have council not have her minute here. She needs it. So
Super. Great. Any other questions for the commissioner or person? Okay, great.
I did want to put on record that a lot of deer hunting happens in snowstorms very safely with the great track record.
I know.
didn't want
So if it's snowing so hard you can't see in front of
Sure.
it, then maybe you shouldn't be shooting something. That was my, I know that people hunt in the snow. It's better for tracking if there's snow.
There you go. I didn't want that to come out. Thank you all so much.
Yes, thank you. All right, Ms. Smith, you ready?
Oh,
If you want to.
I don't have too much to add.
Go.
I didn't feel.
Well, if you wouldn't mind just shouting up if that's okay, that'd be great, thank you.
The only comment that I would add to the testimony, sorry, for the record, my name is Sam Smith, I'm from General Counsel of County Fish and Wildlife. And just the context, the reason that the language in Title 10 is different from the criminal trespass language in Title 13 is because of this constitutional right to hunt fish. And when the language was originally adopted, it was intended to be used by landowners so that they could protect their own land so they could hunt on it. So there really are two diverging reasons there's a reason why the laws are written differently. Why there is a strict liability standard for posting, enclosing your land for hunting and fishing versus the reasonable person standard that's applied in typical criminal trespass. So.
Wait, I'm confused by that. It was the trespass, sorry.
No, go for it.
Okay.
It's great, yeah.
The trespass. Law was put into place to say, I can't trespass on your land because you wanna hunt on it, so you don't want me on your land hunting and taking the game that you might get. Is that the concept?
The ability to enclose your land against the public hunting and fishing on it was intended to protect your right to hunt on your own land. You get first dibs.
First dibs at the game, yeah, okay, that's what. But has it, I mean, it seems like it has grown beyond that.
Yeah,
That it's more than about hunting.
absolutely. The context has changed.
Yeah.
And the language in 5201 has not. It hasn't changed dramatically. Minor changes have happened, including notably the hunting by permission language, which was added a couple years ago, which was intended to really encourage a discussion between landowners
Yeah.
and their neighbors about what they were allowing and what they could tolerate, because there's strict liability. And you wanted to avoid somebody unintentionally violating the enclosure law.
Oh, the language in Title 10, not in Title 13.
Correct, yeah,
Okay,
yes,
yeah,
right, a couple years ago, we added this ability to also post against hunting without permission.
right, so it can say, my neighbor can hunt on my land, but you can't.
Right.
Cause you're.
The public can, but if I have that conversation with you, yes.
Yeah, okay.
And didn't Fish and Wildlife Department actually provide at one time the hunting by permission only signs?
I think we still
Yeah.
provide all of the
So,
signs if you.
so that's another, talk about reasonable, the department's trying to work with the landlords to get them to be reasonable about allowing people to hunt. Cause I can remember one of the disadvantages of being old is that when I was a game warden, we used to have people that would post their land and then expect the game warden to come up and patrol for them. And I said, no, the district warden I work for, and these guys know who they are, who he was, would say, unless it's posted in accordance with Title 10 Fish and Game Law at the time, I can't come up here and enforce your land. So we would actually have to go out and patrol property to find out if it met the letter of the law. If it did, then when he called, that she suspected somebody was on that property hunting illegally, we had to go respond to it. Some wardens would use that as an excuse not to go to that call, because, well, this guy's a problem, he's called a number of times, but yeah, it's complicated, it really is, and if it's gonna be enforceable, I think we need to stick with the Title 10 version.
And just to the commissioner's testimony, that the department the wardens will enforce whatever law is decided. I think it's just important for the committee to recognize how the reasonable person standard changes the way that enforcement will be pursued.
Just, excuse me, as I am observing, strict liability, intent doesn't matter. Reasonable person, the intent does matter.
Right, the way that it's written right now, it says that if a reasonable person believes that hunting is prohibited, then they'll be charged, but yes, that's can be difficult to establish depending on the context.
Okay. I feel like first day with the bill is.
Yeah,
It was.
Just a little bill.
Yes.
Yeah.
That's
These last words.
thank you.
Thank you.
I'm sure we might have more questions.
Yeah.
Okay.
I actually think we might wanna. Talk about, I'd like to hear a little bit more from Russ afterwards.
The intent.
Their discussion about this issue, because we didn't really get into it with him, and now that I understand a little bit more about it.
Yes,
Representative
unless you were not.
You were just.
Representative Sacklett said that Vermont was the only state that requires dating signs and posting in the nation, is that correct? Anybody have that data? Are we the only state that requires?
I don't know. Great question. Happy to dig into it for you.
They kind of sounded like when he said that, they were leaning towards, well, we're the only state in the union, why are we still doing it?
I think some of that can be answered by, if you look at states that require signs, how many of them actually require you to see the sign before you're liable for trespass? Texas has been thrown out there as a state that is right to hunt, uses purple paint. But purple paint or not, right to hunt or not, you may not go on other people's land. Or you may not, and in Vermont, that's not the case. So some of it's apples and oranges, some of it is likely apples to apples, but we can find that out for you.
That would be helpful,
Yeah.
if you're able to update us, even with like something written, that would be great.
NCSL might have, yeah, NCSL.
Especially what are our neighboring states do? That's really.
Sure.
Yeah, that would be educational for me too.
Yeah.
Yeah, I bet NCSL can get us that.
Yeah.
But it's not, I mean, there are people who come here to hunt from even far away.
Oh, I know,
Yeah.
but a
Mhm.
lot of people cross borders.
Sure. All right, okay, before we move on, I just want to check in with Colonel Steadman. We also had you on the list, but we kind of brought you up sort of simultaneously with the commissioner. Was there anything more that you wanted to add to your testimony on the bill?
No,
Okay, sure. Great. Okay, then we are gonna move to, there's quite a few folks who wanted to testify on this. And there's more that are even listed here, so but we're gonna start with Mr. Welcome. And I apologize, I'm gonna have to leave at 10:15 or so, so don't be surprised. Okay.
They don't have to do with me.
Yeah. Welcome.
Thank you for having me. My name is Jeffrey Mack. I live on Vermonter. I live in Shoreham. I have had a lot of experience now with posting property and never had a problem with deer hunters. My problem has always been with hounders. I have been posting my land to keep hounders off my property, and there is some really difficult issues with posted land and keeping your land posted and being in compliance. People will know that keeping your signs up, you know, going to the clerk is easy. You go sign up every year with the clerk, and that I do. And I do live in a windy part of Vermont, and where I happen to live, the wind does blow. And I've had hounders, one parked across my road a couple years ago. He was staring at a poster sign dated, the year, was on his phone. And what he said was, I'll bet you his land is not legally posted. I'm gonna release my dogs on his property. I said, that's probably not. He said, well, I'll bet you there's a sign down somewhere. He ended up not releasing his dogs on my property, which I was thankful for. And Christmas Eve of this last December, I had a hounder drive down the road, stop his dogs in the road before they got to my property. My property, every hounder in the county knows my property is posted for a reason, and that's hounders. He stopped his dogs, he pointed his dogs to the scent because a coyote had just been flushed and ran across my property. And he let those dogs continue across my property. I got it on security camera, I filmed it on my phone, I called the game warden. Game warden came, we discussed what happened. The first thing he did was take out his phone, start his measure tape, start going around the property looking at signs. We got the one sign that wasn't dated properly. He said, you are now not in compliance. We don't need to look any further. So when I hear testimony about being hired to prosecute, if all the signs aren't dated and there's one down, Well, I can tell you from experience, it's even harder to prosecute. Even though you are absolutely, everybody knows, including the game warden, including the hollander, that the intent was my land is posted and they don't want you on it with your dogs. Like I said, to this day, he denies that he let his dogs go on my property. Even though I got it on 2 cameras, he said he did not do it. So I'm a big fan of purple paint. Purple paint can take all that away, dating, signs blowing away. I got a sign that I go by every day that's hanging by one staple on somebody else's property near my house. And the wind's blowing it, ready to take it down. If this bill does not pass, that line will not, that land will not be in compliance. That land is not legally posted anymore. So if we want property rights, this is not about hunting rights, this is about property rights. This is about people staying on my property with their dogs. It's very clear, you cannot, and if my land was in compliance. If that hollander did not want to show his log, his dog, where they've been to a game warden. They would actually have to get a warrant. To seize those lots and look at those lots to see if those dogs are actually, who was telling the truth? The landowner with cameras or the hollander saying I didn't do it, I didn't do it. So I am a fan of purple paint. Purple paint would take all that away. They wouldn't blow away. They'd be less than 400 feet. Register with the town every year, 2 years, whatever you wanted. But it wouldn't have to be dated. It's landowner rights you have on their property. Who, when and where they want, and right now. It's not possible, it's almost impossible, if you have a large parcel. There's gonna be a sign down. It's not gonna be dated, right? And that's just, we all know that, so purple paint or register with the town. Everybody carries their phone in their pocket, there's many apps that will show you exactly where my property lines are. If you went to the town and saw my land was posted, you got on your phone, you could see exactly where my property lines were, you would know. Where I was, it, you wouldn't have to be on my property. If you were an ethical hunter, you wouldn't come near my property. So this is where I see it, this is my experience, and I want to be able to prosecute somebody, especially when they intentionally let their dogs go on my property.
Thank you very much for your testimony. You bring up a really good point about the apps and how technology is to the point where it's a lot easier to see property lines and to see exactly where you are in relation to the property line. You can literally see your little dots on the map and be like, oh, I'm on this side of it versus that side of it. And I don't. Do you really use the technological?
Onyx is a very popular one that you use.
Yes.
Yeah.
That said, my neighbor's property is all around, like, it's in and out of Italian. It's only as good as the records that it.
Right,
takes
okay.
information from.
That's fair, I'm just wondering, to the extent that it's used, and
Yes, we do it.
what I'm hearing from you, and we were chatting a little bit before your testimony too, is that the standard for keeping the posting signs in good condition and, now dated, but also just even up there and 400 feet apart, that's really hard to do on a big piece of property and in a windy area. I mean, I know Shoreham is really windy.
Sure is.
So when you heard this discussion we were having about the reasonableness standard on both sides, and I was trying to say, is it, what I was hearing is 2 reasonableness standards are hard, but maybe 1 would be better, and are you comfortable with a reasonable language for landowners in the bill saying if you've reasonably tried to maintain your posting signs and then your land is legally posted as long as you've registered with the clerk?
Well, like Carol said, that it's still gonna be really hard to prosecute. This is, this is where the whole issue is, and
Mhm.
like I said, everybody in Wyoming was posted, but they still literally let the dogs go on my property, knowing that there's probably gonna be a sign down. So if they know that game wardens are gonna have trouble convicting or finding somebody guilty of either way we do this bill, then what? It shouldn't be hard to prosecute somebody for being on your property when you have all the intent that you don't want them there.
And the purple paint law would be better because it is like a permanent marker on the trees or
Permanent. It
whatever.
doesn't have to be dated, it's not gonna blow away.
So purple paint isn't in this bill,
No.
look it up,
No, I know, but I'm just,
okay.
Yeah.
I mean, it's still on the table as something to talk about, if
Correct.
we're getting testimony on it. So, just go ahead, you were in the middle of a sentence.
Like I said, as we hear how hard it's gonna be to convict somebody either way, the purple paint takes that away because it'd be out. We go to the town, you register. We can go measure and all purple paint's there and okay, now we gotta work with whoever was on your property. That'd be the next step.
And if we don't, if the bill doesn't have purple paint in it, and if we don't feel like we can go in that direction, is there something we could do to tighten up this bill to make it easier to make sure your land continues to be posted?
Yeah, I would say you register with the town. Every hunter, no matter what they're hunting, would have to go to the town, see where the area where they're hunting. And I would, just like Colonel said, Onyx is a good one. You're on Onyx, you're registered with the town, it's their responsibility to know where the posted land is. You know, why is it the landowner's responsibility, the huge burden on the landowner to make sure his land is in compliance when he doesn't want somebody on his property?
So did you ask anybody to prosecute?
The warden told me, he looked at that one sign and said, your next one's too far, you are not in compliance, there's nothing I can do. Quote unquote.
So your point is it's still hard to prosecute even without the reasonableness standard?
Correct.
Because it's, these minor issues with signs make it really hard.
Correct.
You own, how much land you own?
10 acres,
10 acres?
yeah. You would think with all the acres they have around them to hunt on, they could stay off my 10, right? Nope. Not the way it is.
These questions?
Well, actually, for a head on more than more than the spurred by your testimony, but. We have intent in the law all the time. It's foundational actually. And in some ways, strict liability is kind of the exception. I guess I'm having a hard time understanding why it's with intent built into this instead of strict liability. It would be so. Why you believe prosecution just wouldn't happen?
Well, I don't think they would never happen, and I think that I would defer to the Colonel for more specifics on this, but the way that criminal trespass is typically pursued is that a notice against trespass is issued first, because then everybody is clearly aware that you are not permitted onto the land. So prosecution typically doesn't happen until there's a second offense. But I think that hypothetically, if there's some, like there could be prosecution, it just creates more discretion for both the law enforcement officer, which is challenging, and for state's attorney.
So from our perspective sitting here, we have to weigh that against the testimony that with the posting system where we have it now, we effectively don't have anything.
Yes, I would say you have to weigh that as well as the purpose behind 5201.
The purpose.
I think if you're looking at the original intent was to put a burden on the landowner, because otherwise there is this idea that you can hunt on land that's not enclosed. I mean, I think that, again, acknowledging that the context has changed, but that's the reason why that strict liability standard was originally imposed.
Can I ask a follow-up question? Sorry, this is a little awkward, but
Do you want to move so you're not turning around? If you move over there.
no, that's okay. It's also sort of following up on Snre Baumgart's question. And you said this before when you were at the table, like in Title 13, because of this more squishy reasonableness standards, let's say, the first violation would be a notice of trespass, is that what, and saying you can't trespass, you can't go on this land for 2 years.
Generally, that's my understanding.
Yeah, that's what happens,
That is how most are.
okay, so if somebody goes on land that's posted no trespassing with a no trespassing sign. And they claim they didn't see the sign, but you know, a reasonable person would have said, oh, there's a sign there. Then they could get a no trespassing violation.
I assure you, there's no way that gentleman got on my in-laws property without seeing any of those signs.
Right,
And
so they got a
notice.
notice against trespassing for 2 years.
Yes.
I mean,
that's how it
it does seem like a notice against trespassing, and and if somebody still does it,
Then they can be charged under criminal trespass.
right, so that would actually be helpful to you if these people who are repeatedly letting their dogs on their land get a notice against trespassing. Then they do it again, then there's a second violation,
I
so,
think one of the things to consider in that scenario, man, is that if that were the case. Under Fish and Wildlife law, they lose their license, under Title 13, they would not lose their license, so they'd still have a license to hunt.
right, but I'm saying that if this were changed and. The reasonableness standard, and maybe I'm confusing this in my head, but. Would they, if this were to go into effect and somebody went on to his property, and that it was determined that a reasonable person should know that his property was posted,
That's what
would they get like a 2-year notice to not go on his property?
potentially, yes.
Yeah, which would be helpful,
Well,
right?
that's what happened. That's what happened in this case, they got a notice of trespass. But there's also, and you correct me if I'm wrong, from what I understand, and I've had this conversation with Jason Batchelder recently. It's 5 points on a hunting license if they're caught in violation.
So I'm not sure the cops 5 points for violating the notice against trespass.
No, 5 points, like if my land was in compliance
Mhm.
and was posted legally. That hunter would have then been issued 5 points on his license, and he already has 5 points. This is the conversation I had with Jason Batchelder a couple months ago, and he said, yes, I would do that 5 points on their license.
10. I think the violation in of
Need
itself.
10.
No, I think the violation in of itself is 10 points. I'm gonna check right
When
now.
he told me it was
Yeah. I
5,
think you might have just got confused on that.
maybe that's,
I think it's more, which in your case would be good.
yes. So for the hunting license, they need 10 for a year suspension, I believe. You're correct. And he told me that it would be a 5 point violation for if somebody had their dogs on my property and my land was legally posted.
Mhm.
You're gonna help it. Tell me about this.
So under this bill, if your land is. There's reasonable evidence that your land is posted, maybe one of your signs is down, but
There
the
was
evidence.
pure intent that my land is posted.
Right, that they could get a 5, maybe 10 point violation plus a notice to not go on your land for 2 years, right?
And it's your loss of license.
It's just
If your land is legally posted and they're caught on your land.
Upset.
But the issue right now is that this isn't happening because it's really hard to maintain your signs because of the nature of your property and.
Yeah, you also gonna walk them every day
Yeah,
to make sure that they're all still up.
okay. All right, no, this is helpful, thank you very much.
So a comment, but it's gonna end up in a question. You know, there are always bad actors in any group, no matter what. So if your property was legally posted and you've been able to issue him 10 points of his license, that would have been impactful if he lost his license.
Correct.
Don't you think that would be a good reason to keep it, Title 10 the way it is? And you know, notwithstanding not putting aside the dating issue, but.
Like I said, you have to be in compliance. Whatever way, this is about landowner rights, whatever way this is written up, it should be enforceable by the game wardens. If you've been violation of somebody on your property, it shouldn't be like, well, it's iffy because one sign wasn't dated, or it's iffy because There was really a whole strip over there was no sign, so was he really trying to post his land? It needs to be enforceable with the 10-point violation. Purple paint be a perfect.
I don't even wanna go with purple paint right now.
Purple paint,
It's not in the bill,
it's
not in the bill,
absolutely foolproof,
so.
just about anyways. Purple paint, when registered with the town, you'd be in compliance every year.
Everybody can go buy purple paint.
Why would you not, why are you against purple paint, may I ask?
Because how many, you know how many property owners actually have their land surveyed? You can go out and paint your line, and next thing you know, you got lawsuits. Because you posted somebody else's property,
Wouldn't that be the same saying signs?
maybe. But
You,
But if I put a sign up, I'm gonna make sure it's actually on my, you know, there's blazed lines on trees. I'm not.
brown
gonna put-
paint covers it right up
Yeah.
if you are wrong, and I'm telling you, these phones will tell you exactly where your property lines are. I mean, I know exactly where my property lines are, my property survey. I know where I've been,
I got 250 acres.
Yeah.
I got 10.
and you probably know exactly where your.
Because I surveyed my land, right, and most people don't.
I love this conversation.
Yeah, but he said the signs would be the same as the purple paint. If I was pounding signs on your property, you would say, yay, you're
Okay.
to my property.
Any other questions?
Okay.
We got people.
Okay.
I want
Thank
to hear-
you very much.
Thanks.
Next one is Carol Dawes, Fairhaven City.
Good morning, committee.
Morning.
For the record, Carol Dawes, I'm the Barry City Treasurer. I'm also the chair of the Legislative Committee for the Vermont Municipal Clerk and Treasurers Association. And I'm going to keep this, I'm not loud enough. I'm never not loud enough.
No, you can hear that. Thank you.
Carol, it's so nice to see you.
You too. I'm going to keep this very short because I know you've got many other people to hear from. The Clerk and Treasurers Association's interest in this bill is very narrow, and it is addressed completely in this bill, and that has to do with the language that takes the ambiguity out with regards to what annual recording is by referring to it as 365 days from the date of recording in the clerk's office. That has satisfied us completely, and it takes away any of that concern about ambiguity about people having to record their document on the 1st of January, which of course is a holiday, or other times that would be inconvenient for a landowner. This is the one thing we were most interested in the bill, and we're very happy with the language. So I'm happy to answer any questions, but you probably just want to go to the next person.
Any question?
Thanks,
Thank you
Carol.
very much. Appreciate it.
You're welcome. I'm going to stay on just to keep listening.
Okay.
Heidi has not. I don't think
So you
she's.
just got, okay. You got Morgan Gold,
Yeah, he's.
Morgan?
Hey there, folks. Can you guys hear me?
Yeah.
Yeah.
Awesome. I apologize for not being there today. I got a feed delivery at noon, so was not able to make the drive to Montpelier a second time this week. But my name's Morgan Gold. I am a farmer out in Peacham, Vermont. I raise beef. I raise goats. I grow a whole bunch of chestnut and apple and elderberry. I also am, based on all available public records, Vermont's largest goose farmer. I have a 160-acre farm out here. The farm land is a mixture of about 50-ish acres or so. That's pasture and orchard. And then the remaining 110 is forest. In terms of the farm, the other unique thing about us that I should mention is we also post videos about the farm online. And I've got a following of roughly 5 million folks kind of all around the world who watch what goes on the daily basis with my farm, my animals, me, and all that good stuff. I've been here for about 10 years now, bought the farm in July of 2016. And in that time, I've actually had 8 different incidents with hunters on the land, and specifically related to posting. That range of incidents has gone from everything like being like, hey, buddy, no, this is posted now, I'd ask you not to be here, to having folks show up in my dooryard at like 12:30 at night and having to call state troopers and game wardens. And even in that instance, not even being able to press charges because I did have a sign that was out of compliance at the time. And so I actually have some real concerns about where this law has been, because I actually also testified to the House committee on this bill, and specifically the removal of purple paint, I think is very problematic and is actively encouraging hunter landowner conflicts. Also, I should probably note that I am a hunter myself. I hunt my land. I actually have my friends and neighbors hunting my land as well. So this is actually not about that, but it's much more about property rights. And I find it kind of interesting and ironic that, like, it seems like for rural landowners like myself who is running a working farm, the way the shape the law is continuing to take is it's making it harder for me to manage my land as a farmer trying to just do my job. And specifically, once a year I go out and do kind of a full update and post all of my signs. We've got a roughly 4-mile border that I've got to cover. That amounts to like 50 plus signs that I'm ending up putting up there. When I do that patrol once a year, I'm usually having to replace missing signs. It's like usually about a 10% rate of signs go missing over the course of a year. These are Tyvek signs, so it's, I'm literally putting about 50 square feet of Tyvek out into the farm every single year when I'm putting these signs out there, whether it be vandalism, weather, mischievous squirrel, like there's a whole host of things that can make a sign go missing. But regardless of that, what that does is put it out of compliance. So I personally don't necessarily feel like the once a year requirement to walk and do the updates is a significant issue. But I will say that to maintain my compliance and ensure that my compliance is maintained, that means I'm doing it like if I'm doing it quarterly, that seems like a little bit of work. If I'm actually doing it monthly, which is probably more what I would really should be thinking about, that feels unreasonable. But again, it's not about a time period of when was the last time you checked your signs. It's about whether or not your signs are in compliance. When it comes to the purple paint component, effectively, I can update it, have a very clear marker, and then what that does is it's very black or white. Was it painted or not? There could be a simple cancel signal that you could always have too, like brown paint it if you're no longer posted or if it's been incorrectly posted. That's a very simple fix. And so it's very confusing to me that there'd be so much objection to something that happens in many other states in a reasonable way to keep your land posted. A couple of other things just to recognize that have happened with this. When I mentioned that incident with having wardens be here, they have told me specifically I could not press charges because my signs were not in compliance. And this was an incident where I had raccoon hunters showing up in the middle of the night, running through my dooryard. Their hounds were actually interacting with my livestock guardian dogs that I use to keep my poultry safe. And so it's a significant issue that if I didn't have the 5-foot high fence I have around my poultry yard, I could have had either my dogs hurt, their dogs hurt, or one of us trying to get hurt, trying to separate the dogs. And so trying to create more ways for landowners and hunters to just interact peaceably, I think is a positive. And so the way the purple paint had been structured in this bill, I think was better than where it is. I think the other piece too that's really important is when it comes to thinking about managing the updates to the signs, just to give you guys a really clear sense of the types of signage I'm doing. I've got about 1,300 feet of my border that sits right on the main road, and those signs are very easy to update, very easy to check on. I've got another, it's about 2,200 feet that runs around a dirt road that has actually been destroyed by the floods that we had here in Peacham back in 2024. It's no longer passable by vehicle. My portion of the land actually sits on like a 50-foot cliff at this point because of all the erosion that's happened. And so for me to even try to update those signs, it's very precarious. And so until the rule about January 1st was changed, I was very worried I was going to have to be like going there with harness and rope, going down a cliff on an icy cliff to try to update my signs. And then actually I've got about the remaining almost 2 miles of property that runs through deep woods. So where it's woods on my end, backing into woods on my neighbor's end. So there's no clear boundary markers. I use Onyx specifically to track and walk and mark my property lines. And so that is the only way I can know that I'm posting the proper space. Yet also, if I'm thinking about, well, why don't you go out there and check your land? Like, shouldn't you? It's deep forest. This is deep wetlands. This is swamp land that I'm actually having to go through to do these things. And so this isn't me not wanting to walk like a far side of it. This is me walking to a place that probably doesn't see a ton of human activity on a daily basis most of the year. And so it's harder to get in there and harder to do that. And so it's fine for me. I'm a guy in my mid 40s. It's not that big of a deal. 20 years from now, 30 years from now, 40 years from now, am I still going to be able to do that? I actually wonder about it because it is such a rugged trail that I have to go through. And I've actually made videos and posted them on YouTube before documenting what it's like to go through this. And so to just keep the mental model in your mind for you folks as you're considering this law, recognize that these aren't all just very clear boundaries that are very easy to see that, oh, here's the road, here's some woods, that's probably somebody's property. This is, hey, here's a mile of woods that goes this way and a mile of woods that goes that way. There's a property line that sits in the middle of it that's what I'm ultimately having to mark. And so just keep that in mind too. If you guys are serious about maintaining just good, respectful hunting culture, I think making this clearer and easier for people to see, not having these issues of Tyvek signs getting ripped off that are just so easy to remove that they get, like I said, I lose about 10% a year. I don't know. I think that's an important aspect.
Yeah. Thank you.
Any questions?
I thank you, Mr. Gold. This is really helpful testimony. I'm wondering, have you had any livestock loss because of hunting violations on your property, or have you been able to keep your livestock safe?
No, I've never had to do that. No, there have not been like incidents like a hunter shooting like one of my geese or anything like that.
No, I'm thinking about the dogs that come on.
No, but I have had cattle get spooked, and I have had cattle incidents, and kind of even seen it through the activity on trail cameras. Cattle either on my end or actually on my neighbor's end get spooked and either come onto my property or come through. And usually that's in the midst of hounding season, like in like early September, particularly when like bear hounding season is really active.
Got it.
Okay, thank you very much.
Thanks, Morgan.
All right, thanks guys.
Where do you want to take a break?
Can I just ask another question of maybe of the Colonel or Hannah before we get to Mr. Bradley?
Sure.
Do we have time? Yes. Okay, could you come up to the table?
I apologize. Yeah, I'm sorry. I feel that.
No, it's okay, it's fine. Our old knack, I'm like. Oh.
No, I mean, it's a difficult setup.
So I was rereading the language as I was listening to Mr. Gold, and it seems to me that the thing that makes your land posted is the filing with the clerk, recording with the clerk, and that the signs are just notice of posting.
Yes, that would be a reasonable interpretation. However, absent any one of those things, it is not posted.
Okay.
You know what I mean? Does that make sense?
Yeah, but I mean, it does say that the signs are just notice of posting,
Correct.
Notice signs. So the actual act of posting is registering with the clerk.
So it's almost like the three-legged stool. It doesn't stand without one of those things. So the language may give that impression, but you have to register currently. You have to register in the town, you have to have your signs, and you have to be dated. If one of those three things is missing, then it is not posted as it currently stands.
Maybe that's up for interpretation.
And that's certainly.
I mean, the way I'm reading it is that that these are notice signs. It specifically says notice,
Yeah.
even in current law.
Yeah.
That you put the notice of your posting, but the actual thing to post the land is you do it with your town clerk.
So that, I believe they say register, right?
Yeah,
Yes.
yeah, the owner shall record.
Record.
Record the
Yeah.
posting. So recording the posting,
Yeah.
filled out in triplicate, oh my god,
Yes,
that's.
we have a copy of it.
Hilarious.
Staff clerk has a copy of it.
That-
We can't digitize it for that reason.
Yeah, that's a little weird, maybe we should think about that, but that's the thing, I think that. You know, to Doug, I'm sorry, it's Jeff, I'm sorry, Jeff's point of, you know, everybody knows his land is posted. It's registered with the Shoreham Town Clerk and it's on all the maps and everything. And the issue is not that his land isn't posted, the issue is that the notice signs aren't always 100% in compliance, so. I feel like that's an actual important distinction. when you're thinking about enforcement?
So
Is that as long as it's recorded, that's the actual posting?
in order to prosecute in court, we have to have all three lists. And in order for those signs, as you said, the notice signs to meet the requirement of the law as it exists, not on the paper, but as it exists in this book right now, it has to be dated.
And has there
It has to be
been a
certain
court,
distance.
has there been a court decision that says you have to have all three, or is it just your interpretation of it?
We have successfully prosecuted it with it. We have not successfully prosecuted it without it, because the case will not be.
But is it, the reason you haven't successfully prosecuted it is because you haven't tried, or is it, have you tried and failed when there's been a sign that's maybe 10 feet?
I personally brought a case when I was a younger warden,
Uh-huh.
where I thought all the requirements were met, and when the defense got on the stand, they said, well, these signs are missing, and the case was thrown out.
Okay.
So, and that's my one personal experience.
So,
Yeah.
get into the details here.
Yes, and so absolutely, so that's my one personal experience. I don't know if years ago they tried to do this, but I can unequivocally say that missing signs and the case was thrown out of the court, and I mean, that was been around a little while, it was a few years ago, but as a general rule, the way we do enforcement is that we will not bring the case if three parts are not there. Because it doesn't get through the first gatekeeper, which is the state's terms.
Well, that's what I was trying to figure out, where's the holdup? Is it because you don't try, or because you're getting stopped? It sounds like.
Yeah, I think it would be something similar to, I don't know what a good analogy would be, other than to just say, we have to meet all the elements as it currently is written, and not having the signs dated, proper distance, and all that. This is one of the elements. And I understand what you're talking about the signs giving notice, and they do. That is the notice to a person says, don't go on here. But those signs, the requirements for those signs, if they aren't met, we cannot enforce it. We cannot, because of course, so hopefully, I know.
Yeah, I mean,
You're asking a great
there's
question.
some nuance here, and that's where I'm trying to figure out, like, what is the actual act of posting? And it seems to me that in statute, the actual act of posting is at the clerk's office. And then the notice of that posting is with the signs. But even if a sign is down, it's still posted because it's been recorded at the clerk's office.
And you're getting on a point that I tried to sort of get at with the sort of recipe and what the end result is that it might look good on paper and your interpretation may be 100% correct, but the other part of the criminal justice system, the part that does the actual prosecution piece, doesn't accept that sort of logic, or has not accepted that.
Right, so maybe this is the way they're interpreting the statute that we written, so, okay.
I would, yes, I'm sorry.
No, I don't hear you sit there.
I-
I don't know, sit there.
Sorry to complicate this.
No, it's okay.
I would argue the language is not ambiguous right now. So the way that the statute's currently written, section D, which starts line 15 of page 2, it states that land posted as provided in subsection B, which is the language related to signage, is enclosed for the purposes of this section. The signs are required.
They're required for notice.
They're required for the land to be enclosed.
Okay, that makes sense.
So the statute's not ambiguous about the requirement that the land both be recorded and the signs be posted.
Okay, that's a good point. And the enclosure part is a constitutional, like the land enclosed is enclosed actually the word in.
That's the word that's used there.
Okay, thank you, that's helpful.
I can see a question.
Yeah, I have a question, for the Colonel.
Maybe that should be.
And I'm sorry, I had to step out for a few minutes to present an amendment in a different committee. But regarding, and kind of circling back to Mr. Gold's testimony, does Fish and Wildlife have a position or a thought on the use of purple paint in lieu of the sun?
A certain subset of society will break the law. It doesn't matter what the law is, right? We all know that. That's why we have homicides and burglaries and all sorts. Purple paint is no harder to circumvent than posted signs. You just carry brown paint with you, or you cut down the tree. It's that simple. And that people might think that outlandish, but if someone wants to do it, they will do it. It doesn't change anything. And the idea that purple paint is an invaluable marker is, it certainly won't blow away, but it is no more difficult to circumvent purple paint than it is a posted sign.
True, but. Cutting down trees and using, I mean, that's an act of vandalism.
It is.
That's different than just a sign blows away and. You know, okay,
No,
I'm just
no,
going here.
Yeah.
Yeah, no, I mean, I think that's a really good point, because I also wonder. I hear you on and if you're trying to break the law, you're gonna find a way. That's unfortunately part of human nature, so
Some people.
some people.
Yes,
do.
yes.
And that's what we try to prevent in this building, but I think looking at it from the other perspective, from the landowner perspective, the purple paint makes it much easier to comply with the requirement of the enclosure. Because that, it prevents the blowing away of signs, faulty squirrel damage. I love that, like squirrels for all this stuff, all that stuff. So that's.
Cross-treating the purple paint here, it's not even in the bill.
It was the original bill, Senator, and it's part,
On this-
it's still a relevant
Okay,
conversation
so
to
we can
have.
have it as a committee.
So I guess thinking from the landowner perspective that's trying to prevent, and it sounds like, I mean, we haven't gotten tons of testimony on it, but it sounds like one of the biggest issues is trying to prevent hounders from coming on with hounds. Cause everybody acknowledges that 99% of hunters are following it, fishermen are following the law and being really respectful. So it's just 1% or whatever.
It's always the one.
Yeah, but so thinking about it from that perspective, wouldn't it make it easier for you all to enforce the law if you don't have to go around and check to make sure all the signs are up?
So I don't know this to be fact, but I will give you my opinion. The current requirements of the posting law, as was expressed by the landowners here, require the landowners to be on the landscape to do the checks, to ensure that they are taking affirmative actions to say, you are not welcome here. Anything that deviates from that, my opinion, because this is based on the experience of the criminal trespass law, which has no requirement for any sort of follow-up or anything of that nature. Anything that deviates from that requirement for the landowner to be doing positive, taking actual positive steps to prevent access is what allows us to overcome. Because let's face it, people go to court and they lie. I didn't do it, I wasn't there, it wasn't me, like that's what people are going to say. And so the onerous, as you've heard, what has been described as the onerous steps that are required of landowners are what allow us to overcome that. And that's my interest in sort of the discussion here, is that in my opinion, and this is only my opinion, and I don't believe a factual way to determine this, but in my opinion, based on the enforcement of Title 13, if you move away from onerous steps that require an actual act every year, I believe we will lose our ability to hold people accountable when the circumstance is met. And as you heard, one sign out of compliance seems like, I understand why you're saying that doesn't seem reasonable. On the flip side, all the signs in compliance, I didn't know, it wasn't me, blah, 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 whatever you want to say, it becomes irrelevant. And
I hear that, it makes it much more black and white, but it sounds like it's hard to,
yes,
to make sure that all the signs are in compliance at every minute
No,
because of various factors.
it's not
And
infallible.
so it sounds like prosecution isn't happening anyway, so like there's the question of which is gonna be worse.
Right, and we.
And it depends on your perspective for sure.
Absolutely, no, absolutely, and we have when the criteria are met, we have absolutely successful prosecuting.
Mhm.
And that has been my experience, has been most work's experience. But yes, it is not without difficulty. But I guess to the point you're talking about, perfect, I don't think that makes it better. I think it removes the requirement to check on your property boundaries, and with all due respect, I can fit about 6 cans of spray paint in my backpack if I wanted to. It doesn't take, it's not hard to go out and just, no, it's no longer close. And I.
It's not hard to rip a sign down.
No, exactly, that's my point. My point is that, you know, there is not, I don't know that there is an easy fix here, and again, my opinion, I think it's because you're balancing something that's written into the Constitution against something that is, I don't know if it's legal or innate, but like, you should have the right to say what happens on your property. I mean, I owe taxes, like, as we all do, right? So I understand both sides of this. Again, if the committee comes out of here and says tomorrow it's whatever, I don't know, farm triangles, like, we'll do the best we can. It's just, I don't think that we can get strict liability, strict enforcement. The
Okay,
diminishment of the requirements, if that makes sense.
yeah,
At the end of the day, if you.
I'm gonna keep calling.
Yeah, no, and if you change it, then by all means, that, you know, we'll do the best we can, so.
Thank you.
You're welcome.
Okay, I'm gonna have to take a break, so we're gonna go offline. Well, he went the same place I did. He got waylaid. Thank you.
We're live.
Keep doing it, people.
We're live, Senator.
Okay, welcome back. Next, testifier is going to be Mr. Bradley of the Vermont Federation of Enforcement Clubs.
Yes, again, for the record, Chris Bradley, Vermont Federation of Sportsmen's Clubs. We're an organization that has existed in Vermont since 1875. Pretty short bill. I'm going to, just as an aside, I know the issue of purple paint that is not in this bill was in the primary bill. And as we heard, I believe it was a 10-to-1, that it was really discussed heavily. And what passed didn't have purple thing. So I guess I'm going to start on page 2, and I'm going to preface all of this by saying we have on one hand we have hunting rights, and on the other side we have landowner rights. And overall, personally, the Federation leans towards landowner rights because hunting has a great deal of responsibility. This 1% or less than 1% that are not, they're doing a lot of damage to otherwise do people. So I guess in taking a look at this, I do manage 290 acres as manager of the Vinyl Homestead Association in East Kaliskalis. We do not post road. We do like people to ask permission, but we do not post. I'm going to start at the top of the bottom of page 1, line 21. You notice signs.
Page 1 point.
Then on the top of page 2, notice signs shall be maintained at all times. And shall be daily each year. And shall be daily each year and taken out. But we really, Federation has a strong stance here. We really do believe that dating should be on these signs. And let's just look at why that is. If you're out in the woods and you see a sign and it's clearly dated, there's no question. But if you see a sign that does not have the date, then there's really a question. And in fact, in that instance, you're going to have to go back to the town clerk to understand whether it's posted or not, because you can't have a sign up when they've never been reported to the town clerk's office. And that would be an illegal posting. So if signs have to be maintained, and nobody's questioned this at all times, I mean, literally, that sounds to me like you're patrolling your perimeter all the time. So if, and I have a suggestion, but we really feel it's very important to leave the dating back in. Because number one, it makes it easier for law enforcement to come in and say, clearly this is dated. And I have another suggestion. As far as the line 5 and 6, the posting shall be valid and enforceable for 365, spot on. That is, I think, was the intent all along. We didn't want people going out in January 1 to December, to post your property. So 365 from the date you actually prepared the posting, spot on. We certainly support that. I guess I'm going to jump down to now. This would be 16 and 17 on page 2. Accidental or unintentional deviations from the requirements of subsection 8 of the section shall still be viewed. I personally find this language problematic. Because in fact, they just throw something out there. There could be an intentional violation. Somebody literally tore down several signs. It wouldn't be unintentional, wouldn't be accidental. It was intentional. Somebody ripped down a sign. And just on that point, I believe there's 2 statutes that would apply if somebody was ripping down a sign. One certainly is a Title 10. As the commissioner said, 10 VSA 5205, which is injury notice would qualify. But even beyond that, 13 VSA 3701C, criminal mischief. Basically, if you're doing something with somebody's personal property that's under, I believe, $500, which is sign. That's punishable by 6 months and or up to $500. So there's some flexibility here as to how to prosecute that. So I guess coming back to it, I do believe that hunters should be aware of it. And if they are on property that they should not be, then there should be repercussions for that. As far as 16 and 17, I'm just making a suggestion. Drop accidental or unintentional. And in line 17, begin the sentence with minor. So minor deviations from the requirements of subsection subdivisions A and B of this section, new insertion, that are beyond the owner's control. I mean, if a sign gets blown down, and I know that I'm walking a reasonableness line here to say on one side, we should be on the side of the landowner. If all of it, the intent is pretty clear, that this is posted right. And I just threw that out there for consideration. But I do feel that a person who is on somebody else's land, there should be a kind of difference. There should be fairly significant. Other than that, there's unlawful trespass if somebody is violating it outside of Title 10. Unlawful trespass, you're fellow on a piece of property you're not supposed to be on, and then you've been ordered by notice sign. Law enforcement can come in and make you aware you're not supposed to be. At which point discretion comes in, and it's not an automatic arrest. The individual who is the perpetrator here, you go, oh my heavens, I didn't know, and they can vacate the property and all is fine. If they don't, then we move to a different level, and you can actually arrest the person. So I guess we very strongly recommend that dating of signs stay in, especially if there is a requirement to maintain at all times. And actually, just as a thought, at all times, I really wonder whether that could possibly be looked at to say at least once annually. I don't think it's fair for a woman to have to literally patrol the property every day, which is really what this is saying. So, again, I would suggest leaving the dating in, unless these bad owners, especially if you should be looking at your signs at all times, and well, just one statement. Are there any other questions for me? I promise to be ready.
I got questions.
Yes, sir.
Maybe this is for the Fish and Wildlife folks, but there's two different issues here. It's two different constitutional issues too. Hunting rights and personal property rights. Along with rights come responsibility too. So there's a responsibility of the hunters to honor the wishes of the landowner. Therefore, there's a responsibility for the landowner to keep his property identified. And that's why I think Title 10 also says that signs shall be no more than 400 feet apart and or within view of one another. So if you got to Mr. Gold's point, terrain's tough. It's not because of some of the flooding we've had. I think it's difficult for me to do. But once the signs are up, so do you think that maybe what we're talking about here is is having Title 13 and Title 10 a problem? Would it be simpler if we had one statute?
Shooting from the head, no, I think we would still want to. Unlawful trespass is used in many other places, stores, for example. No shirt, no shoes, no service. I think that's a very distinct purpose, although no trespass can certainly be used on property. But again, it's discretionary. So, I guess I would have to think about it a little bit more, but shooting from the hip, I think they serve two different distinct purposes. And yes, I wrestle with this as well. The landowner rights versus the constitutional right down. And when I look at this, I have to say, the landowner there's responsibilities on both sides. But I think the responsibility of the hunter knowing where they are. I mean, that seems to be proven out from the testimony that more often than not they do, and this isn't an issue, but the bad actors, I have no sympathy. Any other questions for me? Told you to be quick. Thank you very much. Split the date back today, we're good. Okay. Thank you very much.
We don't have anybody now until 11:30.
Okay.
We're live.
Okay, hello everyone, this is Senate Natural Resources and Energy, and we're coming back from break. And we are looking at a amendment, so potential amendment, from Senator Matos to 325. Just to flag it for everybody, I did have a conversation with Senate Economic Development about our amendment to S 328. They have some further changes they would want to suggest, which I'm happy to tell you about. So we'll do that, I think, at the end. Okay, but going to 325 now. Senator Matos, welcome.
Thank you.
Yeah.
Thank you for having me. For the record, Senator Chris Matos, represent the Chittenden North District. What you'll have in front of you, I won't go through it. It's a bit longer of an amendment, but really it's only a couple of changes within that section. I think for reader assistance purposes and speaking with Ellen, it just makes it easier to show those as the full section. Premise of the amendment is for the tier 1B areas. Currently it's set at under 50 or under units created, and then the parcel size has to be 10 acres or less. So this is in the areas where we want housing growth. It's a tier 1B area, suitable soils, town water, town sewer might be there. But what we're running into, what I'm seeing and hearing is that there's parcels out there that are over that 10-acre threshold that are in areas where we want this development done, and providing, I have an example, not even in my district, just over the boundary on the other side of the road. But there's an area that has 27-acre parcel looking to do 34 units. The development is concentrated in an area as shown. I brought a little picture for everybody. I can circulate it around. It has a little red dot where the area is, and there's development all around it. There's commercial development, entertainment areas, there's residential development all around it.
The red dot is 27 acres.
That just shows you where the general parcel is. So really the development in that area is concentrated up towards the road, Saber Drive or road, I forget if it's a road or a drive, but it's concentrated up towards there because of the topography of the land. It's 27 acres. Topography of the land, sensitive areas, can't develop in those areas, but the issue is the overall parcel goes above the 10 acres and automatically puts them out of being able to divert by Act 250 in an area where we want this housing, where you see where there's already an abundance of housing and development around it. This amendment would strip away that 10-acre requirement. So in tier 1A, there's no requirement on parcel size, as you all probably know, up to 75 acres in that tier 1A, but tier 1B then has this 10-acre come in, and this amendment would in interim and in the permanent take away the 10-acre rule in that sense.
So what would be the maximum? Would it be the same as tier 1A or?
Well, tier 1A doesn't have
No maximum.
a maximum, it's just the number of units created. So tier 1A is 75, tier 1B is the 50. And from a cost perspective, when you're building a development like this, you want to limit your infrastructure. So it's not going to be going all throughout the land, because roads cost a lot of money, sewer costs a lot of money, water costs a lot of money. So in the case of a development like this, if many others in the state try to concentrate that, lessen your infrastructure burden because there's no money in roads, so to speak. It has to be caught up in the sale of the home. So I liken it to the fact of, if you had 3 20-acre parcels side by side, and you currently, if you wanted to stay out of Act 250, get under the thresholds of 10 units, if you had 3 separate developers, side by side, you'd be using up 60 acres of land for 27 units. Or if this was tier 1B, the parcel size wasn't there, one of those 20 acres could utilize that land to create 27 units. and be able to put housing where we want it, where there's infrastructure or suitable soils. That's kind of the crux of the bill. I know it's part of the governor's bill, S 267, that's up on the board for having that part removed in the interim and in the permanent Act 181.
So thank you for bringing this. I have a number of thoughts about
Absolutely.
this. So one of the goals of Act 21 in general, right, is to encourage dense development, compact development. And so one of the concerns I have about striking the 10 acres in general is that then there's no boundary. Right, it's just open at that point. And so I think that would be a potential deviation from the policy as it was envisioned to function. But I am very sympathetic to the situations that your folks are in. And so I want to try to find a path forward if we can. And because it sounds like the projects that you're describing are just like exactly the kind of thing that we have, that we've been talking about, that we're hoping for. One of the potential paths forward is because as I understand it, it's the reference to the tract of land being less than 10 acres that's being prohibitive in this situation, right? Which is being interpreted as the parcel size. And my in one interpretation of this could or perhaps should be that the parcel size is irrelevant, that it's the development, like we're trying to build compactly.
Yeah.
So I think there might be a couple different ways to achieve that. One possibility is to instead of, well, actually there's two other, there's like at least one other thing I want to talk about, but one possibility is that instead of striking on a tract or tracts of land involving 10 acres or less, we strike on a tract of land. And so it would be 50 or fewer housing units, or I'm sorry, 50 units or fewer of housing involving 10 acres or less, involving 10 acres. And that way, if the parcel size becomes irrelevant, it's just about the project. I think there was another word I heard floating around.
Is disturbance, is that the word?
That's the way,
Yeah.
I think that's the way you would do it.
So
Because Act 250 uses the word disturbance, I think, and so saying something like a disturbance of 10 acres or less.
It's a great thought and I really appreciate that, but what I'm thinking of as it's brought up, your stormwater infrastructure, it may go off into an area that gets that stormwater where it should go. So is that gonna be qualified, right, is that gonna be disturbance? Those areas can be larger. Usually, if you have a retention pond or you have a swale that has to cut down through to a stream, whatever it may be, is a road, because during construction, it's usually privately maintained as you're building, and then eventually it's turned over to the town, assuming it's up to the town regulations. Would that be part of the disturbance, because now it's actually a town right of way through that area? Because those questions don't come into play in 1A. If we're talking about density, if you had a 27-acre parcel in 1A, you could build 4 houses on it, and you wouldn't have the density, but.
So perhaps just limiting it to 50 units or fewer of housing on 10 acres or less is actually more, somehow more generous than saying just disturb the land, because it could be disturbed for other reasons.
Like lots, do you mean the lot size? So part of Act 181 was providing 5 units per 1 acre, so 1.2 acre lots that say get to 50 on 10 acres, right? That's how the math works out. So would that translate to, if you're creating 50 0.2 acre lots you're gonna get them 10 acres. So that takes out your thought of stormwater, that takes out your thought of the actual, road.
That's the
That-
first time I've heard that math done out loud, so thank you.
I'm in finance.
Or no, it's not, okay, Ellen is correcting me.
Don't look at.
Nope.
I'm not co-signing what he just said, but maybe.
Oh, okay, because I was gonna ask.
I'm just having it.
I was just gonna ask. Senator Bongartz, because you've been working on this for a long time, what was the logic of the 10 acres?
I don't remember that.
Okay.
Go ahead.
I'll check out the Council Legislative Council, it relates to the other jurisdictional trigger of. 10 acres being an Act 250 jurisdictional trigger.
Okay,
Mhm.
and so
And
that,
these are towns that have zoning.
Yeah.
There would be otherwise a 10 acre track, trigger.
so was trying to make it parallel, I see.
And yeah, I joined this conversation, I'm sympathetic to them, but I'm wondering. Here, this, we have just getting this, we haven't had to think it through. I think I'd be comfortable doing this with the interim exemptions for now. And coming back to it next year with time to actually definitely make sure. That we're, 3 years is a lot less than opportunity for having made a mistake.
Yeah.
But because given how this is kind of the session we are, let's think it out loud, so making decisions, but but I'm really sympathetic. And I would not agree with this for the interim period, for the interim exemptions, and but make sure that we bring that here and possibly make it through.
And I think, just. As well, thinking out loud in the 50 units, the 10 acres, how it all works is that. That sprawl, if you will, might be mitigated by that unit. Per acre, the 5 units per acre, getting it in under that 10 acres, so it would. I would think it would create a sprawl because you wanna, obviously, highest and best use of your property, what you wanna achieve, so. Having that 10 acres just be the lots created versus including stormwaters, disturbance and roads and whatnot, but that's just. That's why, but I appreciate the.
And if we did that, if we did your language, which would cover also the stormwater and roads, et cetera. Right?
It would just take the 10 acre.
Yeah,
off
if we did it for the interim period, like Senator Bongartz is suggesting,
Yeah.
would that help this and the other developments that you're contemplating or trying to?
From what I've heard, if you have a.
4 years.
If you have a project in place, I mean, if you could get something up and running by that time, there might be other ones that pop up, but. The amount would be lessened because it's during the interim period, and you can actually see how it goes, right?
Well, I wanted to just check in to see what it was that you, because I was making a different suggestion to keep the 10 acres, but make sure it's not tied to the parcel. But which part were you, I just want to make sure we're clear what you were
Okay,
suggesting.
fair enough, because I was thinking just remove the 10 acre.
For the
In the Salem, on the interim.
not
As
the.
long as it's
Oh.
so of course, if we know it's within the.
And that's what we
in the
know,
area.
yeah.
It won't be,
No, not would be yet,
Interim.
in the interim. Which is the interim exemptions, which is effectively. It's a proxy for what would. What's the end of the one here?
2030.
In 325, we moved it to 2030.
Right, it would be that, it would be the 1B.
Because if we go back next year, well, that was a mistake, but
You can blame me.
We got it.
We'll do that.
I appreciate that.
3 years.
So going with Senator Mattos's language, but just for the interim, and then we'll revisit for. Next year on
Nicole,
tier
yeah.
1B.
I think I can get on board with it.
Right,
It makes me very happy.
Senator.
Yes.
So you make that happen.
I think
That's
we
me.
just have to unstrict,
Yeah,
I'll let the person that knows.
I would redraft it, but can I ask
It's in the calendar.
can I ask you a question though before you leave?
This one, oh, it's not, that's why you need to change. Did you talk about this?
Do you want to do that?
Oh,
At the bottom of page 3.
yeah, so the bottom of page 3. Also, it talks about, you know, in areas of municipality, census designated urbanized area of over 50,000 residents. And within 1/4 mile, I changed that to or 1/4 mile of a transit route, so that would include.
What is
I-
this referring to?
I have not wrapped my head around this. I think this could have a lot
Yeah,
of implications. And not necessarily opposed, we would need to take a lot of testimony on that particular part, because. With the and, we know where we're talking about, with the or, could be. There might just be some implications that there could be a lot of implications actually that we're not thinking right now, so again. You know, let's take it up.
in the interim,
Yeah.
should we do it in the interim part and then for the permanent? So it'd be the 10 acres and the or for the interim.
I don't know what this is referring to. I don't know what this is.
This is part of an interim exemption, it's the 50 units of housing for the interim exemption, and the first part is either in areas that are village areas, et cetera. Or in the urbanized areas that are within 1/4 mile.
Okay, with over 50,000 residents or 1/4 mile of a transit route, and is a transit route an official?
Defined.
Yeah.
I'm always asking you if things are defined.
We need to really we need to really have time to. I don't want to do this.
Yeah,
Just said I had time to think.
The and or.
Yeah, the and or,
It's not made, who knows, but.
I'm happy to flag it for the house,
Yeah, I mean, that's.
yeah. Yeah, there's just a lot that could now catch and I wanna think through that.
No, I do appreciate it, the 10 acre.
Okay, thank you.
Thank you. So.
Okay, so the logistics from here.
I'm gonna take out the first part, or leave it in the interim sessions.
Yes,
First part of it,
yes.
Yeah, because our big one is the tier 1B.
Yeah. And then, and we're not doing the and or for now. Thank you, okay, happy to have more conversation about that in the future. Okay, thank you.
Thanks.
Thank you, all right, to be continued. All right, so we have about 10 minutes, and we have at least one other, do we have another amendment to?
Yeah.
We might.
We might.
Yes, sir. This, Senator Weeks, welcome.
I don't
Thank
think there's an amendment.
Good morning.
Just as
See you
a
there.
question,
Was hiding in plain sight.
I'm not
Senator Weeks, I know you had some language, were you able to send that to Ellen?
Yes, Ellen actually picked it up,
Okay, and so
which I
you,
sincerely appreciate.
I'm gonna send it to Jude right now.
So I'm
Okay.
going to give you, it's the same language, it's only 5 words. So I'll give you something preliminarily.
There you go.
So I'm Senator David Weeks, represent Rutland County, and here to offer an amendment to S 325, which really is modification of Act 181. The amendment is intended to support home building. The amendment only affects tier 1A application process. Currently, to achieve tier 1A status, you must have municipal staff in-house for the purpose of capital planning, development review, and zoning administration. This amendment simply allows the municipality to contract with the RPC or other contracted capability for the same purpose. As a practical example, as you know, many villages do not maintain an in-house staff for this purpose, and without this specialized staff, they become ineligible for the tier 1A status. So I'm simply recommending that we add the words behind municipal staff, we add the words RPC or contracted capability to the language. And I'll give you an example. In my world, we do not in business have every specialization in-house all the time. We contract for what we need when we need it, and then we dismiss that capability when we don't need it, and it keeps us lean and nimble. I recommend the same thing for municipal staffs. Seems like a reasonable request, but I'll leave it to your consideration.
Thank you. It looks like you have some thoughts. I also have thoughts. Go ahead.
Part of the intent behind 1A was to in fact have a staff and have them permanently, because this 1A is always going to require staff. So one fear would be that if in fact town backs with it, gets 1A status, and decides next year cut the budget, and doesn't do it, would they lose their tier 1A status?
Again, I think that when you need a specialized staff, you contract for specialized staff. So it would come and go. So in 1 year, if they're applying for this status, they would contract for it to make sure they have the in-house subject matter experts. And then if they needed it again in the future, they would do the same thing. They would contact our RPC. That's the concept.
So
So the short answer, probably no.
my understanding of the need for the staff was not just for the application process, but for the ongoing, it's really about having staff in your municipal planning department, let's say, who could be the zoning administrator, or who's the person, who are the people in that in those roles. Because it's not, at least as I read the need for staff, it's beyond, because I'm appreciating what you're saying, like if it was just for the application, that's like a one-time thing, apply and then we're done, and that would make a lot of sense for a contract. What I'm recalling is that the need for staff is to say, do you have the capacity to enforce your ongoing permits that have been issued? And so the anticipation is that it would be a need every year to enforce zoning. Yes.
True, but it may not be the need for every year of every working hour of the day, and you recycle
Yes.
in response. You don't just contract for, you don't have staff, in-house staff for something you don't need when you don't need.
Yes, go ahead. Oh, sorry, I saw, sorry, right, first then.
Okay, yeah.
I'm just wondering if, I was just looking around to see if we had that in the room, and I don't see them in here. I'm just wondering what they think of this, because it would be. Have you talked to your regional planning commission? Are they cool with this?
In short, no, but
In short, no, they're not cool, or short,
short,
you
no,
haven't
I
talked to them,
haven't.
okay,
You just thought it's such a low hanging fruit
yeah.
for the goal of building houses.
Totally, I mean, I'm not necessarily opposed to it, I just wonder if that's something that they feel like they could take on, and what the implications would be for their staff, and also if there are sort of sufficient experts to contract with, so I just don't know what, it seems benign enough, but also I'm just not sure of the implications.
I'm also sympathetic to this, though, I would say, and because my vision of how, like the need, oh, I'm sorry, I'm jumping ahead. Senator Beck, you're in line, go for it.
Yeah, my only thing is just in the language, the way I read it, the way it's drafted, is that the municipality would have to have all three of these.
Mm-hmm.
And I don't, is that your intent, Senator Weeks?
No, the intent is, that's why the award is there, is that they would have one of the.
But I thought you were saying that they would have municipal staff or the RPC.
Or the RPC or the contractor. Be one of them.
Yeah.
Subject matter expertise would come from one of the three. If the language isn't right or clear enough.
Yeah, I mean, it's because it says it has each of them.
Well, that's because there's so many criteria for the, so when it's referring to each, it's,
Okay.
so this is I, this is paragraph I out of, I don't know how many.
They don't have it written. This is, yeah,
I have, that was the draft.
okay,
Yeah,
I think I'm reading correctly.
Okay.
Okay, that's good, okay.
Yes.
So you're thinking they would have municipal staff, RPC staff, or some other contractor, one of those three.
One of those.
Okay, got it, okay.
Yes, go ahead.
No, I was just thinking that it might be in the RPC's wheelhouse, I mean, my district. They have 27 municipalities, and they are experts in this, that in most of the smaller towns don't have the staff to make that happen, so it makes sense to look at RC and maybe put it into their wheelhouse
Well,
if their staff.
well, and to be fair, tier 1A is a big deal, right? Like it is enforcing all of the Act 250 criteria under the municipal auspices. So this was in here to try to ensure that they were adequately staffed to be able to handle that. And I am sympathetic to this, but I have this concern too about what if, I mean, I'm speaking as a former mayor. Like, because my recollection from contracts was exactly as you were describing, where you contract for the services you need, and then you don't when you don't. Like they're very they're nimble, as you said, and in a way, nimbleness is like not a thing that we want for tier 1A. However, I also recall, and this may be, I'm curious for your experience in this as well. My recollection with contracts was that it was often more expensive to contract with somebody than to have somebody in-house. And so one possibility was, I'm just gonna say this out loud. Well, what if, and I'm, so just backing up, I have a potential option. But maybe Senator Hardy doesn't
Yeah,
know.
I do too.
But I would say for now, like I would be uncomfortable putting this forward without hearing from BAPTA. Again, this is maybe the kind of thing that if we had another 3 weeks, we could probably figure out, like, because I think it's, I'm appreciating where you're trying to go with this. There are logistics around that I think we want to think through. I could see potentially contracting for this service as a kind of a bridge to tier 1A, right? Like, and maybe there's because we don't want it to be like it's on again, off again, like, oh, now you don't have contracted staff, so all these projects are left in the dust. So one, and I'm curious for the Senator Hardy's thoughts as well. I'll just put on the table, one possibility is that we could say, hey, DHCD, would love to see how contracts could be worked into a bridge or transition into tier 1A for those municipalities that are emerging in that or wanting to go in that direction. But that's a report that I'd be asked for, which is not the change that we're asking for, but I'm trying to, you know, see what can I do that can get us partway there. Especially given the time that we have. But Senator Hardy, you have some thoughts.
Yeah, so I was thinking. Something along the lines of. Instead of putting it as a list. Adding language, so it says municipal staff adequate to support coordinated, comprehensive and capital planning. And then another line that says something like municipalities may contract with RPCs or other experts to ensure sufficient capacity year-round or something like that. So that it's saying you have to have staff, but if there's one specific thing you need that has expertise, you don't wanna have a full staff member that knows about whatever, you contract for that.
A supplement.
To supplement, that's exactly the word, supplement. Or your RPCs might be the mapping experts you look to or something, and you contract with the RPC for that. So it's a sort of like, you have the staff, but you supplement it, so it sort of gets at what I think you're trying to get at, is that not all towns are gonna have all the expertise in-house. So this would just, they may contract with RPCs or other experts to supplement, I like that word, municipal staff. Something like that.
I would love to, oh, we are over time. It's fast. Are we okay going for a few minutes more? Yep, okay. Because my inclination would otherwise be to like, take a quick break. You know, otherwise, unless you have something to.
No, I'm sympathetic to this, and I think there will always be contraction around the edges, and I think that happens all the time,
Mhm.
or contraction with the RPCs. But as you said, the 1A is intended to be a big deal,
Mhm.
and we really are intended to truly have the municipal capacity to do it. And what you're interjecting is the notion is how municipal capacity can also include contracted for services, and that's not off the wall, at all, and but I just don't think we had time to consider this. There are implications, there are gonna be unintended. We would need to take hours of testimony to really understand what we're doing, and this is just too important to do. Just a quick amendment for me, and what I would be really happy to spend time on it.
I would love
We
to,
actually could do even later in the session, even though we could spend time and use some of our time after the fact to do some thinking.
well, that's an interesting thought, so, because it's gonna come back to us anyway, and. So. One possibility is that we could pin this one for a potential further proposal of amendment, let's say, from the House if they don't end up taking this up. How do you feel about that?
Well, I think it's just, I think it's important that we're having this conversation and it continues in the House and then comes back to the Senate. The deed is done. At least we've talked about it, consider it as an option.
Okay, I mean, I'm comfortable with that, if you're comfortable with that. I appreciate you bringing this as a topic. I believe Senator Hinsdale has something.
Let me, sorry, otherwise it's gonna show on my face anyway.
Oh, I'm sorry.
I think Senator Reese had something else to say.
Oh, did you have something else to say?
Oh, I did, I wanted to pass the baton to
Oh,
my
okay,
colleague.
and I can help you also with the amendment, you know, because I can still be in touch with somebody about that.
Yes.
So for the record, Senator Kate Hinsdale, an original author of Act 181 and chair of economic development at the time. And I do want to remind us of a few things because there is a lot of shared jurisdiction around tax increment financing districts, downtown designations, and authoring a lot of this bill. Number one, I just want to remind us that we do say in the bill that passed in 2024 that every community should have some ability to access all of the tiers. So I don't want us to be, if we say it's kind of a big deal, I don't want that to mean they have to have, professionalized, a suite of professionalized staff. That was part of our original agreement to get where we got. Just secondly, we had a specific discussion between the two committees, between natural resources and economic development, about how many volunteers, select board members, etc., end up contracting during times of flooding to really figure out how they're going to rebuild their downtown. I mean, that happened with Weston, that happened with a lot of communities that might not get to 1A, but we were incredibly sympathetic to the idea that most of what we give out in government is a lot of one-time grants. So it's a lot of, okay, here's $75,000 to do your bylaw modernization. Here's, a pocket of money because you do have a small a small wave of Act 250 amendments to deal with. We are often giving our communities only one-time money, even if we give it every year. We're not really giving them the capacity, like we don't have in state government often, to go beyond a limited service position. So our regional planning commissions in our rural areas often do make up that ongoing continuous oversight. So we had a full discussion 2 years ago about how much in our areas that could be eligible for 1A, but have used the attorney on their select board or, somebody else. They contract right now also for TIF.
right? So TIF is a big deal. You think TIF is a big deal. Most, at Killington has a TIF, for example. We've already, CHIP is gonna be added to that. We've already said we want infrastructure in these places. We don't then require that they have the staff. They often contract regularly for that.
Good job, Bruce.
Yes, thank you. This is fair, and also sounds like, we're gonna come back to it, which we'll have some more time. So, thank you. And thank you, Senator Weeks, for bringing this up. The third amendment that we're gonna be seeing on the floor is Senator Benson's amendment that we talked through yesterday. So, we've had that conversation. We'll probably just meet for
Take a quick recess.
well, yeah, we'll just take a quick recess before we know.
Can I have a thought on Senator Benson's amendment?
I wanted, because we're over time.
Yeah.
And so I want to go through 328. Actually, can we just chat offline about 3?
Yeah,
Benson? Okay, let's do that.
Yeah.
That'd be great. Thank you.
Right.
Okay. 328, Senator Ron Hinsdale was there also in economic development. So as you may recall, our amendments struck Romanet I to try to make it clearer that it was just the second part. I'm gonna start with the consensus at first. I think they wanted to work a little bit on the farm worker housing report to include, I think, on-farm housing as opposed to we're not just calling it farm worker housing, but because we wanted to include the farmer in there as well. So there's some minor tweaks there. And then they were fine with adding the fire district as well, so that was good. On this portion, something that they were interested in was the sentiment, the intent that was in Romanet I. So they're aiming to not include the distance. There's no 2,000 feet identified any longer, but keeping Romanet I with just striking out the portion that says state regulations or permits. So the whole thing would say an area served by municipal sewer or water means an area where residential connections and expansions are available to municipal water and direct and indirect discharge wastewater systems and are not prohibited by identified capacity constraints or municipally adopted service and capacity agreements.
What does that do?
So it's eliminating the portion.
Yeah, what does that translate to with that, the language you just read it does what it effectively does what?
So it keeps the intent that it's for residential connections and expansions where they're available, because I guess that is mentioned later on as well, but it would eliminate from relative to current law, it would eliminate that it's not prohibited by state regulations or permits. Which, to be fair, anyone's gonna have to get a state permit anyway, so that's. I think it's fair.
Okay, without seeing it, it's hard for me.
And so what I believe is gonna happen is that we'll offer our amendment, and I think they're gonna have a substitute amendment.
We do, yeah.
Okay, so it's not, okay,
It's our entire committee's substitute amendment for this.
I see,
Yeah, which is why we don't have it actually.
okay.
But fair, that it's hard to, so maybe one of the things that we.
Trying to remember after we just talked to all these things about.
So what we could do is, I mean, I said from my perspective, I was like, I'm not speaking for the committee at this moment. I was like, I think I'm fine with this. Open to being wrong about that, but what I would anticipate is that if we could, we'll talk about our amendment. They'll offer their substitute amendment, and then if we can recess real quick to just check in with each other after we have the language, and then we can go from there. Okay. All right, okay. Exciting day. Oh, I'm sorry, there's one other thing, which is a handout that I am going to be giving to everyone on the floor, which is data that came to me from the Federal Reserve. That this is about Vermont specific building permits for housing. You can see over the last 10 years, it's been relatively flat with some spikes, but Act 181 kicks in the summer of 2024, and then we see some pretty fabulous spikes in housing permits. If you were to add, the data as it was given to me, I haven't done the calculation myself, but if you average all of the data from 2017 to like up until Act 181, and compare that to the average after 181 is implemented, it's a 39% increase in housing permits, which it's all of Vermont. So this is not broken down. Well, that's fair. I'm just saying Vermont is in a housing crisis, understood.